introduction. Thank you so much to the Chamber for having me. I am an attorney, as Erica said, at Johnson Jackson PLLC. If that sounds familiar, it's because Christopher Bentley also works there. So thanks, Chris, for having me and giving me this opportunity as well. I'm super excited to talk about today's topic, which I'm going to share my screen, is on minimizing implicit bias in workplace decisions. Make sure I'm sharing the right screen. And hopefully you all can see that. So to start, I want to do a couple polling questions just to make sure we are all on the same page about what implicit bias means. I'm sure I'm preaching to the choir here. I know that the Chamber has done a lot of efforts on diversity and inclusion this year, so some of these will feel easy, I'm sure, but we'll test you guys. There we go. So the first question, or true or false, is an individual's implicit bias aligns with their declared or believed beliefs. And I'm going to put up a poll so you guys can answer true or false. And what I mean by believed beliefs is whether the individual sincerely believes that they believe that way. So it's sincerely held. Okay, I see. Wait one more second to get a few others. There we go. Okay. And it looks like the results, I'm going to end it now. So it looks like 71% of you all said true. So let's see what the answer was. It's actually false. So implicit bias refers to the attitudes or stereotypes that affect our understanding, actions, and decisions in an unconscious manner. So that's dangerous, right? Because it's unconscious. We don't have full control over where our implicit biases lie, which, as we'll get into a little bit, can be problematic in different workplace decisions such as hiring, firing, and discipline, because we don't really have control over it. We may honestly and sincerely believe we think one way, but some experiences, some stereotypes internally that we have may affect our decision making. Okay. Another true or false. Bias is about disliking certain groups. I'm gonna go to the next polling question. So I've launched that poll. So true or false, bias is about disliking certain groups. And I'll give you a couple seconds to answer. Okay, a few more seconds, get any stragglers. All right. So it looks like 63% said false and 38% said true. You can see the results. And the answer is actually false. So more often than not, it's actually about favoring certain groups of people, right? So a really, kind of common example is, say you're interviewing, or your hiring manager is interviewing someone, and they find out during the interview process that they're both members of the same church, right? That may bring up some biases favorable to that individual. They share the same religion. They automatically have something in common. So you can see how favorable biases actually, more often than not, can be very influential. It's not just about disliking certain groups, which we often commonly associate with bias. Okay, true or false? Mandatory diversity training does not always help employees shed their biases. I'm going to put the poll up. There you go. So true or false, mandatory diversity training does not always help employees shed their biases. Give you all a couple seconds to think about that and answer. Couple more seconds. All right, I'm going to end the polling. Share the results. So 100% said true. And that is, whoops. And that is 100% correct. It's true. So statistically speaking, there are studies that show that mandatory, keyword mandatory, diversity training actually results in participants reporting animosity towards other groups afterwards. And this is especially true where the training is mandated for punishment reasons. For example, if you have a manager, maybe they said something insensitive and you force them to undergo this training. Statistics so far show that this type of training is not particularly helpful. Rather, studies show that voluntary training is much more beneficial. And one example of kind of of implicit bias training kind of everyone was talking about at one point in the media, if you recall, in September of 2018, Starbucks had a very public incident after a video went viral. It was showing 2 Black men had been arrested at a Philadelphia Starbucks. And as a result, Starbucks actually closed 8,000 of their stores for a 4-hour training on how to combat implicit bias. So of course, you know, obviously it seemed well-intentioned, right? It seems they were thinking in the right direction and trying to improve and combat bias. And notably, they actually had the Harvard Perception Institute, which a lot of the studies I've seen and I cite too and rely upon come from on implicit bias. They actually had them do and create the training. However, the public had mixed, mixed reviews. So because the problem with training is it's just a couple hours, right? So even the creator of the training program said that they shy away from training altogether because it's not possible to retrain our brains within a 4-hour period. Rather, the goal is to create more awareness of how bias works and apply that awareness on the job. And of course, that goes back to the fact that implicit bias is unconscious, right? So a 4-hour training may have short-term goal benefits, but it's not necessarily going to change how we behave. And of course, as you all know, given you're all focusing on diversity inclusion at the Chamber, a lot of interest stemmed from last summer, especially in summer of 2020. And this is a picture of the Black Lives Matter protest on Bayshore Boulevard. When all of these events were happening last summer, we started to see how different companies were reacting. And so, for example, we saw large corporations like Amazon and McDonald's. Here, Amazon stating in a public statement, "Together we stand in solidarity with the Black community, our employees, customers, and partners in the fight against systemic racism and injustice." So you see that they're issuing different types of statements, standing in solidarity. So this is another kind of short-term way that bigger companies were showing, hey, we want to change things. We want to make efforts here to improve, whether it's implicit bias or diversity and inclusion efforts. And even, in what we do, we practice management side employment law. So we help companies with their policies and handle employee issues. And we had, a large client that said that they had complaints on Facebook from employees that were waiting for a statement like this. So it was interesting to see what steps companies were taking to kind of show solidarity and efforts and implicit bias awareness they were taking as a result of what was going on. And more recently, in spring of 2021, there was an increase in violence against Asian Americans, which again, we see that companies, again, standing in solidarity with their employees and customers, issuing statements showing that they intend to further diversity inclusion and implicit bias awareness. So here, Sundar Pichai is actually the CEO of Google. He issued a statement on social media. And then Andy Jassy, who is from Amazon, who I believe actually just replaced Jeff Bezos, issued a statement as well. So why am I talking about all of this, right? So the reason I talk about it is because today I'm not focusing on implicit bias awareness. I'm talking about taking the long view. So we've seen that short-term trainings for managers can be beneficial, especially if voluntary. We've seen that statements from companies, employers showing they're standing in solidarity has short-term benefits. It shows that they're willing to make change, make efforts, increase implicit bias awareness. But today I want to talk about taking the long view, meaning the standards and procedures and tips that businesses can take to obstruct and disturb biases from coming into workplace decisions. Because if we don't have kind of objective standards and procedures and tips that we're implementing, it's really hard for a short-term training to have long-lasting effects. So that's what I'm talking about today, is what we can do kind of in the long term, implement within our businesses and our policies and our teams to ensure that we're not only aware of implicit bias, but we're ensuring that it's not making its way into workplace decisions, such as hiring, firing, and discipline. So there's obviously benefits. I'm going to focus, because an attorney, I can't help myself, I'm going to focus a lot on the benefits of implementing these procedures, not only as it pertains to minimizing implicit bias, so it will, but also how taking these same steps also minimize legal risk and help defend litigation down the road. Another benefit that studies have shown, it boosts morale when you start implementing these kind of policies and procedures in your companies and businesses. Employees notice, much like those one-time statements, now you're taking kind of an active approach to minimizing implicit bias. It makes for better teams. Studies also show diverse teams means diverse problem solving, creativity, increasing innovation, and then also boosting profitability. So businesses want to work, and you can see this in the chamber itself. Businesses like to work with other businesses where their values align, especially as it pertains to diversity and inclusion. As a law firm, now you're finding clients want to work with law firms or other companies that also are taking on these same efforts. So it also boosts profitability in the sense that you may actually garner more interest in your company because you are taking these active steps to minimize implicit bias. And so I'm going to get into a little bit of the legalese here, not too much. Obviously, a whole presentation can be just done on discrimination, but I just want to touch upon it because I think it's important to show the connection of how implicit bias can make its way into these workplace decisions. And obviously that has negative impacts, but it also can down the line lead to legal risk and liability in the long run. So general overview, Title VII is the big federal law that generally prohibits discrimination because of race, color, national origin, and sex. As of June 2020, Title VII also expressly, based on court decision, protects sexual orientation. It also prohibits harassment. So essentially, the main principle to keep in mind here is that employers cannot take adverse employment actions against an employee because of those protected characteristics. In addition to Title VII, there's other federal laws that also prohibit discrimination based on disability, pregnancy, age, so all very similar. And so one theory that an individual can pursue if they're going to file, for example, a lawsuit under Title VII is a disparate treatment. And this theory is often raised by disciplined employees who claim they were treated differently by their employer compared to other employees who committed similar offenses. Now, taking that theory, first off, it shows that Title VII and similar laws do not only prohibit overt acts of discrimination, right? It covers those more subtle instances. And you can see how implicit bias can make its way into that, because say, for example, someone has this implicit bias, maybe they're favorable towards one type of individual over another, and they subsequently treat those employees differently, say, for example, in discipline. Maybe they both relate for work, but they give favorable treatment over someone else of a different race or different gender or similar protected characteristic. Now, because of that bias, you're now setting the groundwork for a potential lawsuit down the line if that is indeed the reason why they were treated differently, if it was that bias that kind of made its way into that decision making. So another theory that can be used to bring a discrimination claim is disparate impact. It's not as relevant for today's purposes, but there is a provision of the Civil Rights Act pertaining to employment opportunities that prohibit, again, not only overt discrimination, but also practices that are fair in form, but discriminatory in operation. And the historical kind of example of that is where you have a, one moment, here we go. Sorry, I was just pulling up your chats. So if you have questions, feel free to please let me know and I'll do my best to monitor it. So you will have the historical example, sorry, got off track, is where an employer had a standardized intelligence test or a high school diploma requirement, and that requirement actually adversely affected Black applicants. And so the court found that that was unlawful discrimination. So even though it was neutral on its face, the employer couldn't justify it based on legitimate business reasons for having those requirements. So again, you can see how the law is much broader than that overt discrimination you may think of when you think of discrimination. And then retaliation. These anti-discrimination laws also prohibit taking an adverse action against an employee because they've opposed discrimination. So for example, where the employee complains of discrimination to the employer, that employer cannot take an adverse action against them. And again, you can see how that's a problem, because even if you're trying not to treat an employee differently, maybe the manager knows that this person complained, it may make them angry. It may make them want to, maybe treat them more harshly than someone else because they made a complaint. So again, it doesn't have to be just bias based clearly on a race, national origin, or anything like that. I mean, that bias can be because this person complained, and we have to take extra steps to ensure that bias doesn't affect the actions we're taking regarding our employees. So I mentioned the adverse employment action language a couple times, and it is a little bit of a legal term. It generally means that it's a serious and material change in the terms, conditions, or privileges of employment. So while the steps we can take to minimize implicit bias are broader than just those decisions that really impact a material term of a condition of employment, it's I think it's helpful to see and be able to identify what decisions actually may result in legal risk versus others. So to kind of give you I have two examples for you all, and it'll be two more poll questions. So in this first example, we're going to talk about an example of an adverse employment action. A white female employee worked at a Korean company, which employed mostly Korean males. The assistant manager left, resulting in this employee taking on supervisory responsibilities, but no pay increase. When a new assistant manager was hired, a Korean male, over the employee lost supervisory responsibilities. Her pay did not decrease, and her job title never changed, and she ended up resigning. So she filed a discrimination claim for unlawful demotion. So in this circumstance, do you believe that the loss of supervisory functions was an adverse employment action, meaning it could support a lawsuit. So you can answer. This was a yes or no. I see it says true or false, but no worries. So I'll take it as a true is yes and a false is no. Rephrasing it, loss of supervisory functions is an adverse action under Title VII. True or false? Okay. All right. So the answer is no. So you can see how this would be different, right? If there was some kind of demotion or decrease in pay, then it would be an adverse action that might have stronger implications under the law. But here, because it didn't have any change other than the loss of some functions, the court found that it was not actually an adverse action. So one more. An African-American employee complains of race discrimination. Employee subsequently received poor performance review. This performance review did not result in reduction of pay or demotion, but it affected eligibility for merit pay increase. So was this an adverse action? Pull up the poll. So was the performance, so rephrasing it, performance evaluation was an adverse action under Title VII. True or false? All right, only one more second. We have 50-50 here. So it's a 50-50%, and the answer is yes. So what was different from the last situation, right? So this was the court found to be an adverse employment action. Here, it's retaliation. And so kind of a trick question. So in retaliation, what is considered an adverse action is a little bit broader because it also includes actions that may deter an employee from complaining. So here, the argument would be that the decrease or the risk of not getting that merit pay may have prevented or made that employee not want to complain in the first place. So now kind of getting to the meat of the presentation, what I'm going to talk about with respect to workplace decisions today is going to be hiring, discipline, and performance evaluations. I also have some slides on investigations, but that really is a topic all on its own. I really only bring it up because I think it is so important to ensure that you have some kind of standard and procedure in place when and if you need to conduct an investigation. So I'll get into that a little bit, but that will be a very broad overview. So hiring, some tips you can take to minimize bias coming into that hiring manager's decisions. One tip is to blind screen resumes. And what I mean by that is redacting the name of the individual, of the applicant. And why that is helpful is because certain names are associated with certain people, whether it is associated with a certain race, certain background, national origin. So taking off that name before it reaches the decision maker's desk will just eliminate that one potential for unconscious bias. It will eliminate the opportunity for that prejudgment to come in when that decision maker or hiring manager is reviewing that resume. Also, I don't think this is as much an issue in Tampa, but you also can redact the address because in some circumstances, the address may also suggest that a person is from a specific background or ethnicity if they're from a specific area. So that's another thing you can redact. And obviously, if you're going to redact resumes, you should do it for everyone, not just one person or two people. Another tool you can use to kind of minimize implicit bias is structured interviews. And what I mean by that is coming up with a list of questions ahead of the actual interview and having that hiring manager or whoever is doing the interview check off and also write down their comments or write down what the applicant said in response to the questions. because obviously you don't want to stick to an exact script. It's okay to have some, some back and forth with the applicant if you're getting along, but you want to be sure that everyone is asked the same questions. Because say, for example, you get down the line, maybe someone says they weren't chosen because of their gender for a position, they're going to say, well, what questions did you ask the other individuals? And if you ask them different questions, it may suggest that you were being easier on one applicant versus another, or being unfair. So using those structured interview questions helps keep the interview on track, and also eliminates kind of the discretion to go off the rails and talk about irrelevant things, which goes to the next point, using skill-based questions. So gearing those questions towards the job that's actually going to be performed, making sure there's a connection between the actual business, your actual business. And it's, there's some questions that generally apply, but, making sure that it's specific to the position being applied for. Studies also show that one way to eliminate bias and increase diversity when hiring practices is evaluating credentials simultaneously. And what I mean by that is, say, for example, you're using that structured interview. And so you go, rather than look at one applicant and all of their answers at once, you look at that one applicant's answer to the first question next to the other applicant's answers to the first question. So you're getting a chance to see how each individual did with respect to each of the questions. And studies show that actually helps give a fair overview of how people did in their interviews. And then also, the hiring manager, whoever's doing their interview, should ask themselves why they feel the way they do when they make decisions. Easier said than done, right? I know. But it's really important to ask why, because without identifying a legitimate reason for the decision you're making, then you're giving yourself the opportunity to allow not only necessarily illegitimate reasons to come into play, but also irrelevant. So managers that are doing hiring, or if you're doing the hiring, some things to ask yourself: do I typically hire the same type of person? When I say a candidate is not the right fit, what do I mean? Who do I like to assign to work on elite project teams? Do I assign the same person all the time? Is it because I like working with that person? Is it because I'm more comfortable with that person? And if you're more comfortable with that person, if that's why, then maybe you should ask, why are you more comfortable? Is it because you go to the same church, or is it because something work related? And what factors do I consider in identifying candidates for hiring, promotion, and succession? So, like I said, easier said than done, right? I know that different businesses have different challenges with kind of pushing their D&I efforts, pushing this implicit bias awareness. But there are some things you can do to kind of get your management and employees on board. One being encouraging them to be engaged. Make sure they're part of the process. Ask them questions. Consider their input. It doesn't have to be, a wall. They can offer suggestions and input with respect to the questions on the interview. In fact, they should be, asked, what questions should we be asking relevant to the job you're interviewing for? So that will also put more accountability and ownership on them. You'll often find that these individuals want to be champions, for the individuals they hire. So putting accountability and ownership on the managers, encouraging participation in the process, integrating these policy or these practices into your policies will make it part of your culture at your workplace. So in the pre-discipline stage, I know that this doesn't necessarily concern workplace decisions, but it is, from a litigation standpoint and a liability standpoint, often where we see this beginning of a story that may lead to the lawsuit. So it starts at that stage. So before administering corrective action or discipline, it's important that you understand the rule allegedly violated, that the person who violated the rule understands what they did wrong. And it makes it so much easier when you can objectively point to a policy or rule and say, this is what you violated. You can investigate the facts surrounding the alleged violation. Of course, a full-blown investigation is not going to be warranted in every single situation. If an employee is tardy, I don't know that that's going to warrant an investigation. Probably only going to come up in more of a he said, she said situation involving more serious allegations. And refrain from administering corrective action or knee-jerk reactions. Implementing procedures that force ourselves and force our managers to take a beat. Say, why am I making this decision? Why am I upset by what this employee did? Offer the opportunity to explain the basis for that feeling and for that decision they're about to make before they do it. So, as I mentioned, pre-discipline a lot of the time is performance evaluations. One of the major things that come up in practice, at least in what we do, is that you'll find that a person gets fired for a legitimate performance issue, but their performance evaluations leading up to that point are stellar. So it's important, even from the beginning, to document any performance issues and be honest and be specific. Again, justify why you're giving that person the evaluation you're giving them, the score you're giving them. And sometimes it helps, and this may be more in larger businesses, but sometimes it does help for the manager to sit down and require that the supervisor or manager sit down and explain the grounds for why they're giving the score they are actually to the employee, because it will effectively force them to be more thoughtful. It's a lot easier to just put it down on paper and forget about it than when you have to explain the basis for what you're putting down as their score. And if you're going to use the term culture fit, personally, this term gives me agita. I get a little bit nervous because culture fit is so broad, and you can see how it can totally include a potential bias. It's important to define culture fit if you're going to use it as terminology regarding performance evaluations or discipline, because it can really lend itself to some unfortunate interpretations. For example, if by culture fit, you mean that the individual is not a team player and they need to be for purposes of successfully doing their job, then maybe say that instead of culture fit, because that could be legitimate, but culture fit lends itself to this person doesn't fit in. And then the question is, well, why don't they fit in? Is it because they have nothing in common with who they're working with? Because then you can see how your implicit biases may make its way into the decisions you make based on that assessment. And so discipline, very similar. It's important to communicate the expectation, apply rules equally. Remember, we talked about the disparate treatment theory that can lend itself to a discrimination claim. It's really important that if you're going to punish an employee or someone for a rule violation, that it's consistently done for all of those employees. However, that doesn't mean there's no room for exceptions, right? It's okay to consider an employee's prior performance and disciplinary record. And it's okay to make exceptions where the conduct is egregious, because it's a new thing every day. It's never a dull moment in employment and employee issues. And so you can never predict everything that's going to happen. So it's important that you give yourselves flexibility to make exceptions, but you need to be able to justify those exceptions. The exception if you can't explain why you're making exception for one person, not the other, then that's a time of you need to ask, okay, is this because of some kind of bias? Is this because of some kind of stereotype I have in my thought process? And of course, again, easier said than done, but the first step is kind of asking yourself those questions and being honest, or having your managers ask those questions. Encourage them to take a beat and ask themselves. And again, so in more managers should ask themselves, has anyone ever made the same error or violated the same policy? If yes, what did we do? Was it the same reaction? Did we handle it the same way? If not, why? Is it because of a different disciplinary history? Other legitimate factor. And then if you can't justify the distinction, it might be worth reconsidering. It might be worth identifying what the real reason is. Is it because maybe that person complained of, issues before, and now we have some kind of bias towards them? Is it because I know this person really well and they're a friend of mine and I don't want to treat them as harshly as the last person that did this? One method you can use, and that really puts a lot of blocks, kind of, opportunities to take that beat and consider why you're doing what you're doing, assess before getting to the end game of discipline if it becomes an option, is progressive discipline. This is not something that we recommend for all clients, but it is something that will force management, or not force, but make management go through the processes before kind of having discretion to maybe be harsher on one person versus the other. So it's generally defined as a system of escalated penalties made known to employees in advance and imposed with increasing severity of repeated infractions. So 3 strikes you're out rule, right? Maybe you get a warning, then you get a counseling, and then you go through those progressive steps. And also it is evidence, it makes you document the pattern of behavior leading up to an adverse action such as termination. It documents it. So for litigation purposes, a lawsuit may not happen until years later, but now, so your memory might be a little off, but now you have this kind of documentation of where the behavior started and where it landed and why you made the decisions you did and the legitimate basis for those decisions. And so here's some don'ts of discipline. It's essentially, they're not too complicated. And I have a friend, Michael Scott, who's every HR person or employment attorney's #1 example of the worst boss. He essentially, although I love The Office, he essentially does everything that we would recommend you don't do. So obviously avoid acting impulsively, avoid disciplining in anger, disciplining in embarrassing fashion, belittling an employee, singling out unpopular employees, imposing or changing rules arbitrarily, and failing to document. So all things that if you put in rules and procedures to kind of help guide you or management, steps you need to take in addressing discipline, addressing corrective action and issuing it, it will kind of take away the discretion that may lend itself to, for example, maybe you have an employee that you feel more comfortable with. And so instead of, formally disciplining them, you choose to take them out to lunch and kind of explain the issues or do it in private. Whereas if a manager doesn't have the same relationship with someone else and they commit the same offense, maybe they'll do it, maybe they'll discipline the person in front of others. So that kind of disparate treatment is avoided if we take those extra steps and say, okay, here's what we do at the first step. Here's what our procedures are to make sure we don't have the discretion, or at least limit it to how we treat, to allow us to treat everyone the same. So I alluded to this before, documentation is key. It's a more effective communication tool because you put it in writing, and it really forces management, it forces you to write down and identify the issue. So then you can look back to it later and you can kind of show that this is the reason I made this decision and that it was valid and legitimate and not impacted, or at least limited the impact of any potential bias that may have affected the decision making. And so one resource, and because I know that you all have been doing diversity and inclusion efforts and speaking on this before, you likely have heard of this. This is Harvard's Project Implicit. They have a test you can take online. That's the link. And essentially, they have different categories of biases you can kind of take for yourself. I don't recommend you, for example, issuing this all to your employees and requiring they take this, but it may be something you want to share. for people to take at their own leisure for their own personal assessment. But you really can take the quiz regarding any bias. There's race, there's gender, there's sexual orientation, there's even weight. So smaller versus larger people, you can kind of do a personal assessment of where your biases may lie, and kind of having that knowledge, then you can even think about that when you make a decision. But I do have another true or false for you all. Let me put the poll. So true or false, there is a large correlation between a person's score on Harvard's Implicit Association Test, IAT, which is the test that I just mentioned and put the link up for, and a person's discriminatory behavior. So I'll let you all take that. Okay, wait another second or two. I see there's a few of you out there that haven't answered. All right. So looks like 67% of you said there is a large correlation between a person's score on Harvard's IAT and a person's discriminatory behavior. Actually, the answer is false. So you're probably saying, okay, well, Ashley, you just told us this is a helpful tool. Why would you say that? Well, it still is a helpful tool. It will still give you some idea of where your biases lie. However, it's not perfect. And statistically, it actually only in bigger picture, it only helps in bigger picture scenarios. So for example, predicting average outcomes across larger entities such as counties, cities, or states. So while it's a helpful tool, this is why I don't recommend requiring, if you're going to kind of circulate this, maybe as part of, maybe you're going to do some training coming up, circulating this to your managers or employees or whoever else, I wouldn't have them report back their results, for example. It isn't going to be a clear indicator of where your biases lie, but it's helpful. It gives you some context. It will help you kind of see personally how you can improve or things to think about, specifically when making decisions such as hiring and firing and discipline. So as I mentioned, I wanted to briefly talk about investigations. And the reason I want to briefly talk about it is because often investigations are what lead to these workplace decisions, these adverse employment actions. And also often, especially with smaller businesses, they don't have kind of standards in place to adequately investigate an allegation. For example, the number one that comes to mind is sexual harassment or a hostile work environment scenario. And the reason why, as an attorney, we do, from a liability and lawsuit perspective, we do care about that is because there is a defense. It's called the Farragher-Ellers defense. And essentially, it gives employers a defense to a claim of hostile work environment if they can show that they exercise reasonable care to prevent and promptly correct the harassing behavior, along with the employee unreasonably failed to take advantage of any preventive or corrective opportunities provided by the employer. So you can see how an investigation, if something happens down the line, you get sued, and unfortunately, we all do our best to be proactive and put in standards and procedures that help us limit liability, but it is just an inevitable part of owning a business, is it might happen regardless of how proactive you are. The first thing we'll do is, okay, especially with a hostile work environment claim, did they investigate and what did they do? And because our businesses often don't have the procedures ahead of that issue coming up, it becomes very important. It's very practical to come up with some standards ahead of the issue you need to investigate, especially because generally, once a complaint of discrimination is received, it's really important to begin the investigation as soon as reasonably possible. So between that time, you're not going to have a lot of time to come up with some fairness procedures, some opportunities to ensure that everyone's treated fairly, opportunities, frankly, to minimize any kind of bias, implicit bias, from making its way into the investigation process itself. So, for example, there's going to be questions you're going to need to ask yourself: who is going to do the interviewing? Who is going to conduct the investigation? For smaller companies, you think about bias coming into play. It's more problematic, essentially, because you have, everyone is more likely to know each other. In those circumstances, it may be worth getting a third party. Like we will, you get an attorney like us doing an investigation. You may want to get that unbiased person to do the investigation, because you want to ensure that there's no bias in the process to taint it potentially. And something as simple as coming up with a decision or a process on who gets interviewed first, who gets interviewed second, kind of limiting the discretion to kind of do different investigations differently from complaint to complaint, because then you want to avoid kind of, if you do investigations inconsistently from complaint to complaint, it might show some level of bias or unfair treatment regarding the way you're conducting the investigation differently for others. So, for example, we generally suggest you interview the complainant first. So if you can cite to, the fact that we interviewed the complainant first, and that's what we always do, then you can ensure there's a level of fairness and consistency when you do investigations, because you don't want the example where you have someone, maybe they're more friendly with the accused than the complainant. And so they're like, hey, I'll just take the accused out to lunch. We'll do the questioning there. It becomes a little bit murky, and you can see how bias can make its way into the fairness of an investigation overall. And same, having some standard procedures for interviewing the accused as well, because maybe your bias lies with the complainant. And so I do have one more example. This will be a quick one, because, as I mentioned, there is a defense that employers can use against hostile work environment claims regarding that will look at the reasonableness of an investigation that was done to kind of correct any alleged behavior. Here's another case where the reasonableness of an investigation was assessed. So here, it was a large company. So here you have the plaintiff in this investigation met with the HR rep, submitted a 5-page written synopsis of the alleged offensive conduct. The HR rep, the president of HR, and the compliance officer all came from their headquarters to this field office to investigate. They interviewed 3 members of the claimant's office. The president of HR interviewed 2 of 4 potential witnesses himself, and the interviews took place in a restaurant, with each of the interviews taking place in different parts of the restaurant at different times, but they were all interviewed in the same place, both the accused and the complainant. So their investigation, they said the claims were unsubstantiated. But the plaintiff argued in her lawsuit that the investigation was deficient because the president of HR failed to take notes, because the president of HR and the compliance officer did not speak personally with the plaintiff. The interview took place in the same restaurant where accused was present, and you can see several other factors. So true or false? It's going to ask as a question, but we'll phrase this as a true or false. True or false? The investigation was sufficiently reasonable. I'll launch the poll. All right, let's see. We got 50-50 right now. All right, I'm going to end the polling. And so it's 50-50. So the answer is yes, the court did find that it was sufficiently reasonable in this situation. So you can see the investigation doesn't have to be perfect, but it definitely helps to have some standards and procedures to ensure that you're making sure that there's no implicit bias, you're limiting the amount of bias that can come in. So that is, I know I threw a lot at you. A lot of this can be just a presentation on its own, but of course, my biggest takeaway for you all is to take the long view, invest the time in coming up with policies and procedures that will help you all ensure that implicit bias is limited, right? We can't control it, but at least we can limit it by taking these extra steps. So if you want my contact information, there's my email. I'm happy to take any questions. I know we don't have a lot of time, so I'll stop sharing. But you can always email me after. Again, my email is agallagher@johnsonjackson.com, and I can put it in the chat also. But I'm always excited about this topic and happy to help. So.
Awesome. Thank you, Ashley, so much. That was a lot of information, but I'm sure super useful to a lot of people. So that was really great. And we did record the presentation, so it'll be on our website later this week, and we'll send it out to everyone who did end up registering.
Thank you.
Have a great week, everyone. Thanks for joining us.